Next up is Kevin Baumgardner, who is a partner in the Seattle firm Corr, Cronin, Michelson, Baumgardner, and Preece. A highly experienced trial lawyer and appellate advocate, Kevin has tried jury cases in the state and federal courts of Washington and Alaska, as well as in multiple administrative jurisdictions, and has argued before the Ninth Circuit as well as the Washington appellate courts. Over the past 10 years, Kevin's practice has been primarily focused on the defense of whistleblower claims in the commercial aviation and nuclear industry. He has defended over 20 such cases from inception to resolution and has never lost one. Kevin has received a host of accolades, including being recognized as a litigation star by Benchmark Litigation. In his infrequent spare time, Kevin is an avid equestrian and is a past president of the United States Eventing Association, the American governing body of the Olympic equestrian sport of three-day eventing. Please join me in welcoming Kevin.
Good afternoon. Let's start with the big picture. Is there anyone out there who doesn't know who all of these people are? Does anyone not recognize these names? And I guess I could ask you, does anyone not recognize their silver screen counterpart names? James Spader would be Daniel Ellsberg. Meryl Streep is Karen Silkwood. Julia Roberts is Aaron Brockovich. And best of all, Sony has just optioned the rights for the Edward Snowden story, and it's going to be produced by the Broccoli family, the people who did the James Bond franchise. So you can bet that that's going to be exciting. And my point is that whistleblowers, in quotes, are lionized by contemporary American media and society. And therein lies the peril for companies who are facing these claims. These really are the two words that you're least likely to see appear together. And remember, perception can be reality. The claimant will always get the benefit of the doubt. And let's actually look at the proof. Here are a number of headlines. These are all just within the last month or so. And note that it's always a whistleblower, not an alleged whistleblower, someone who is a self-described whistleblower, who claims to be a whistleblower. And in fact, if you look at the Wall Street Journal article, the second one down on the left, the subheading says, ex-employee who initiated visa practices investigation alleges company retaliated against him. So there's that magic word, alleges. But they're talking about his claim. They're not talking about his, again, self-described status as a whistleblower. And who knows, he may be a whistleblower, but he may not. He may be he or she may be a disgruntled employee who was incompetent, was perhaps fired for incompetence, perhaps fired because no one could get along with him or her. We just don't know, but uncritically, that label, once someone appends it to themselves, and particularly if they take on a big corporation who's kind of an ordinary suspect target, that's going to be picked up by the media, and you're not going to get a lot of benefit of the doubt if you're on the corporate side. Whistleblower protection statutes in the 21st century, I mean, this is a growing area of the law. And if, you know, there's been a lot of talk about how Congress can't get anything done. I guarantee you they're getting done passing a lot of whistleblower statutes. And they've been doing that for the last 15 years at a pace that is proliferating almost exponentially. And these are just examples. There are new ones every year. I was interested. I was talking to Art Levy from American Management Associates, and he told me that New York now has a requirement for a program for nonprofits to have a whistleblower program. Who knew? So again, throughout a wide range of industries, and I would bet the industry that your company is in, there is whistleblower exposure now. This is a new development that anyone who works with a company that contracts with a government agency should be aware of. This NDAA, this is very broad. It just came into effect July 2nd of last year, only applies to contracts that either have an ex post facto addition of this or that were awarded after July 2nd of 2013. But it has a very long statute of limitations, at least in the whistleblower context, a 3-year statute of limitations. Since whistleblower claims tend to be kind of ephemeral things that are brought when, when the heat is on, people, as was said in an earlier presentation, whistleblowers come out of the woodwork. But this gives someone 3 years to decide that whatever conduct they engaged in, whatever retaliation they think they suffered, that they are a whistleblower and have a claim. It also has less stringent administrative burdens, including a quicker ability to get to federal court through a kick-out provision than many other whistleblower provisions. It also has a sunset provision, which is, I believe, 5 years. So it is a pilot program, but I haven't seen, any retreat of this trend in new whistleblower cases. Let's talk about the way that the company is at a disadvantage when these claims are made. And I should note, just as a threshold matter, there are many different procedures and forums that you'll be subject to. I mean, some claims can be brought directly in federal court, some in state court in various states. Other claims, I handle claims often in the nuclear industry under the ERA, the Energy Reorganization Act, or under Air 21, the commercial aviation industry. Those go to the Department of Labor, and there's a Byzantine administrative process. But most of them have very expansive definitions of protected activity, so that, and this is important, think about an airline mechanic. I've handled this case. Someone who repairs airlines in the graveyard ships, so they're making repairs that have to do with the ability of the plane to fly. By definition, that person is working on a safety-related issue. So if he sends an email, obviously it has something to do with the safety-related issue, but it may be that person's ordinary scope of job duties. But under Air 21, that can, certainly be swept in, even if he didn't step outside those duties and say, hey, I've got a specific safety concern that I think needs to be reported. That can still be protected activity that you can base a claim on. The materiality of the adverse impact, the adverse action, is seldom required. So often when you get a slap on the wrist, a warning letter, something that doesn't affect compensation or real world working conditions, still something that can be sued on. Very low standards of causation. This is what we see in many of these whistleblower programs set up by these special statutes, that if the safety-related concern is a contributing factor as opposed to the predominant factor. There can be 5 or 6 other factors, all of which have to do with the person, engaging in frank misconduct. Still you've got a live claim there. And then, of course, one-way costs and attorney's fees, recovery provisions. And going back to the administrative point, that adjudication can really be a crapshoot. You have ALJs involved, you have administrative boards involved. You really have to learn who the people are who are involved in this, because often they're political appointees, and so depending on what administration is in, they can really change their viewpoints fairly extensively. And then you have what we call the gift that keeps on giving, which is the frequent filer. And I'll tell you that people, even within the whistleblower adjudication industry, in other words, within the DOL administrative process, they will use this term because there are people who do this, who file claim after claim, and while claims are pending, they apply for a new job with the same company that perhaps fired them or didn't hire them or didn't give them a promotion, and they keep filing another claim saying that this is just a continual pattern of retaliation. And there is a fellow who is the acknowledged master of this named Syed Hassan, who filed at least 28 separate retaliation cases that went through just multiple levels of appeal. He was eventually sanctioned by the Second Circuit, but then after that, another case that got dismissed actually got reinstated by a Department of Labor board. So it's very hard for the courts to handle this type of abusive process. How do we take the air out of the whistle? Well, the first thing you do and this is very important, is implement a robust compliance program. That is a totally different CLE topic. I'm not going to talk about that, but certainly that is something that needs to be done with these types of statutes and claims in mind. When a claim does arise, and they will, because this is an inevitable part of doing business in some of these areas, you have to hire an experienced, skillful trial lawyer, one with experience in whistleblower cases, immediately. And by the way, don't hire a law firm. Hire a lawyer who may be with a law firm, which is fine, but hire a lawyer or a team of lawyers who you can work with and who you trust. And then get going, because whistleblower cases are all about marshaling the evidence and who does it first. And this I've touched on. Many whistleblower cases really are, you know, they're not based on reality. They're often brought by people who had other grievances or were terminated for incompetence or other reasons. Now, that's not all. I mean, there are authentic whistleblowers who are truly retaliated against, and they take advantage of these statutes too, and they're entitled to. If you find a claim that, you know, once you've done your investigation, that's one that fits within that, then I think you go into a different mode, which is settlement mode. But we're going to talk about litigation mode here. Here's the game plan. First, and I mentioned this, seize the day. A lot of claimants' lawyers file lots of these claims, and they figure they're going to wait to try to get to trial. I mean, your job, as we all know, is to get summary judgment. Whether you're in-house or an insurance company managing this, or you're the lawyer in charge. Get summary judgment or win at trial if necessary. And marshaling the evidence at the beginning of the case is so important. Depositions can make or break your case. These cases are about the issue, reframing the issue, and about whose motivation is at issue. It's going to be two ships passing in the night, and the ships are, on the one hand, I was retaliated against because I'm a heroic American who brought up all these safety concerns or financial concerns or whatever, and the other one's going to be, no, these are the true motivations for this person. And whoever, you know, gets their ship underway first is going to have a huge chance of winning that battle of the competing narratives. And of course, focusing on the terminology early, this is so important. Case terminology early in the case, if you sit down and you think about it, you think, we don't want to use this word. We want to instead use a different word. Often the other side's not thinking about that. And going to the next slide. Look at those. Those are two ships that took off from San Francisco, okay? 10 degrees apart. They're still within sight for a long time because they're only 10 degrees apart. But the Pacific Ocean, or in this case, the life of a whistleblower case, being something that's very big and very long, that those small gradations are going to mean that the ship on the left ends up in Hong Kong and the ship on the right ends up in Tokyo. And, you know, if you want to end up in Hong Kong and not Tokyo, you better take the path of the ship on the left, and you better do it early. You can't do it right before trial and start using terminology that you think wins the case for you. Do it early when the other side will acquiesce. They usually do because they haven't thought through it as much. Now this touches on some of the other presentations that have been made today, but gathering and reviewing and analyzing the claimant's documents, obviously important. We're going back to motive. It is so important to learn from personal electronic files, which include discovery of their social media files, as well as the company email accounts, which you'll often have, because this has been someone who was an employee. Get those early, preserve them, obviously, no spoliation, but start looking through them and start preparing a witness file for this person, and do a psychological profile, in a sense, as you're doing it, particularly if you suspect that there is a motive that has nothing to do with being a whistleblower. Don't do this before the deposition. Do it at the beginning of the case. Now, Larry Polk mentioned the kind of the nightmare scenario where a whistleblower is still employed by the company, and that raises all kinds of other issues that I'm not going to get into. But obviously, if that's the case, you need some specific legal advice on what your duties are to that person while they're with the company, and also how you protect the company. Gathering the key company witness documents at the outset. Watch out for privilege breach issues. That's very important. If you're terminating someone for any reason, but certainly when you think that person might become a whistleblower claimant, lock them out from computer access before you terminate them, because we have seen downloading of company documents by people who want to use them as whistleblower claimants. And again, you find out if there's a real problem too. If you find really bad documents, again, this may be a case to go in settlement mode. Do your interviews early. And again, this is subject to all the cautions we've heard about from Larry and from others. But you need to do that to identify the good evidence as well as the weaknesses, and to develop that psychological profile of the claimant. What makes that person tick? And of course, you also need to know who are the good and the bad and the ugly among the company witnesses. Deposing the whistleblower, this is where you make or break your case. This has been my experience in whistleblower cases. With someone who's bringing a whistleblower claim that's not well-founded, you win it at deposition, and then you bring that home in a summary judgment motion. Always videotape, always. If you go to trial, you're going to be putting that claimant's credibility on trial, and you need a videotape. The trial lawyer insists that the trial lawyer take the deposition and use the deposition to tell the defense story through the claimant. Use their documents aggressively. And again, the precise shades of meaning, the rule of 10 degrees, incorporate those into deposition questioning. Seize the terminology. Ask the ultimate questions, and give this person plenty of rope to hang themselves. This was a case I actually handled, a deposition I took in 2003 in an Air 21 whistleblower case. And you can see, again, with the other guy not knocking over a pitcher of water or doing something he probably should have, the other lawyer, I just asked this guy, is it fair to say you were never aware of any actual safety violations by the airline? That's fair to say. So you're not claiming Mr. Smith or any of his superiors ever did anything to compromise safety, are you? Oh, no. End of case. Summary judgment right there. So don't, preparation. Don't neglect that. Very briefly, defending company witness depositions. Remember, you're talking about video depositions. Television, a cool medium, credibility is everything. Preparation is everything. We talked about mock trials earlier, mock video sessions. And I'm just going to, in the few seconds I have left, mention a special challenge, which is the CEO deposition. I've defended a few, and let's face it, CEOs have special personalities. There may be a few here. They sometimes will give a bad answer just to tweak their counsel. Also, they've honed skills through negotiations and through meeting with analysts, so often know how to kind of bluff and bluster their way through that type of a high-stakes interview. You don't want that. You want to retrain that. So that's where you really have to apply these skills. Media strategy, I'll let you review that on your own. Thank you very much.